Chapter 3, Part 3 of an Essay on the Trial by Jury. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Beth Ann. Trial by Jury by Lysander Spooner. Chapter 3, Part 3 Ad questionem juries non respondent juratores. To the question of law, the jurors do not answer. The notice says that this is indeed a maxim in the civil law jurisprudence, but it does not bind an English jury, for by the common law of the land the jury are judges as well of the matter of law as of the fact, with this difference only, that the (a Saxon word) or judge on the bench is to give them no assistance in determining the matter of fact, but if they have any doubt among themselves relating to matter of law, they may then request him to explain it to them, which when he hath done, and they are thus become well informed, they, and they only, become competent judges of the matter of law. And this is the province of the judge on the bench, namely, to show, or teach, the law, but not to take upon him the trial of the delinquent, either in matter of fact or in matter of law. Here various Saxon laws are quoted. In neither of these fundamental laws is there the least word, hint, or idea that the earl or alderman, that is to say, the praepositus, presiding officer, of the court, which is tantamount to the judge on the bench, is to take upon him to judge the delinquent in any sense whatever. The sole purport of his office is to teach the secular or worldly law. Ditto, page 57 in note. The administration of justice was carefully provided for. It was not the caprice of their lord, but the sentence of their peers, that they obeyed. Each was the judge of his equals, and each by his equals was judged. Introduction to Gilbert on Tenures, page 12. Hallam says, a respectable class of free secagers, having in general full rights of alienating their lands, and holding them probably at a small certain rent from the lord of the manor, frequently occur in the Doomsday Book. They undoubtedly were suitors to the court baron of the lord, to whose soc, or right of justice, they belonged. They were consequently judges in civil causes, determined before the manorial tribunal. Second Middle Ages, 481. Stevens adopts as correct the following quotations from Blackstone: The court baron is a court incident to every manor in the kingdom, to be holden by the steward within the said manor. It is a court of common law, and it is the court before the freeholders who owe suit and service to the manor, are bound to serve as jurors in the courts of the manor, the steward being rather the registrar than the judge. The freeholders' court was composed of the lord's tenants, who were the pares, equals, of each other, and were bound by their feudal tenure to assist their lord in the dispensation of domestic justice. This was formerly held every 3 weeks, and its most important business was to determine, by writ of right, all controversies relating to the right of lands within the manor. 3rd Stevens Commentaries, 392-3. 3rd Blackstone, 32-33. 100 court is only a larger court baron, being held for all the inhabitants of a particular hundred, instead of a manor. The free suitors, jurors, are here also the judges, and the steward is the registrar. 3rd Stevens, 394. 3rd Blackstone, 33. The county court is a court incident to the jurisdiction of the sheriff. The freeholders of the county are the real judges in this court, and the sheriff is the ministerial officer. 3rd Stevens, 395-6. 3rd Blackstone, 35-6. Blackstone describes these courts as courts wherein injuries were redressed in an easy and expeditious manner, by the suffrage of neighbors and friends. 3 Blackstone 30. When we read of a certain number of freemen chosen by the parties to decide in dispute, all bound by oath to vote in foro conscientia, and that their decision, not the will of the judge presiding, ended the suit, we at once perceive that a great improvement has been made in the old form of compurgation, an improvement which impartial observation can have no hesitation to pronounce as identical in its main features with the trial by jury. Dunham's Middle Ages, Section 2, B2, Chapter 1, 57 Lardner's Cabinet Cyclopedia 60. The bishop and the earl, or in his absence, the Urefa, sheriff, and sometimes both the earl of the Urefa, presided at the shire mote, county court. The Urefa, sheriff, usually alone presided at the mote, meeting or court, of the 100. In the cities and towns which were not within any peculiar jurisdiction, there was held, at regular stated intervals, a burgmote, or borough court, for the administration of justice, at which the Urefa, or a magistrate appointed by the king, presided. Spence's Origin of the Laws and Political Institutions of Modern Europe, p. 444. The right of the plaintiff and defendant, and of the prosecutor and criminal, to challenge the judices, judges, or assessors, appointed to try the cause in civil matters, and to decide upon the guilt or innocence of the accused in criminal matters, is recognized in the treatise called the Laws of Henry I. But I cannot discover from the Anglo-Saxon laws or histories that before the conquest the parties had any general right of challenge. Indeed, had such a right existed, the injunctions to all persons standing in the situation of judges, jurors, to do right according to their conscience, would scarcely have been so frequently and anxiously repeated. Spence, 456. Note: the jurors were sometimes called assessors, because they assessed, or determined the amount of fines and amercements to be imposed. End footnote. Hale says, "The administration of the common justice of the kingdom seems to be wholly dispensed in the county courts, 100 courts, and courts baron, except some of the greater crimes reformed by the laws of King Henry I, and that part thereof which was sometimes taken up by the Justarius Angliae. This doubtless bred great inconvenience, uncertainty, and variety in the laws, viz. First, by the ignorance of the judges, which were the freeholders of the county. Thirdly, a third inconvenience was, that all the business of any moment was carried by parties and factions. For the freeholders being generally the judges, and conversing one among another, and being as it were the chief judges, not only of the fact but of the law, every man that had a suit there, sped according as he could make parties." First Hale's History of the Common Law, p. 246. In all these tribunals, county court, 100 court, etc., the judges were the free tenants, owing suit to the court, and afterwards called its peers. First Lingard's History of England, 488. Henry calls the 12 jurors assessors, and says, "These assessors, who were in reality judges, took a solemn oath that they would faithfully discharge the duties of their office, and not suffer an innocent man to be condemned, nor any guilty person to be acquitted." 3 Henry's History of Great Britain, 346. Tyrrell says, "Alfred cantoned his kingdom, first into trihings, and laiths, as they are still called in Kent and other places, consisting of 3 or 4 hundreds, in which, the freeholders being judges, such causes were brought as could not be determined in the 100 court." Tyrrell's Introduction to the History of England, p. 80. Of the 100 court he says, "In this court anciently, one of the principal inhabitants called the aldermen, together with the barons of the hundred. Note: The barons of the hundred were the freeholders. Hallam says, "The word baro, originally meaning only a man, was of very large significance, and is not unfrequently applied to common freeholders, as in the phrase court baron." Third Middle Ages, 14 to 15. Blackstone says, "The court baron is a court of common law, and it is the court of the barons, by which the name freeholders were sometimes anciently called, for that it is held before the freeholders who owe suit and service to the manor." 3 Blackstone, 33. Id est the freeholders was judge. Ditto, page 80. Also he says, "By a law of Edward the Elder, every sheriff shall convene the people once a month, and do equal right to all, putting an end to controversies at times appointed." Ditto, page 86. A statute emphatically termed the grand assize enabled the defendant, if he thought proper, to abide by the testimony of the 12 good and lawful knights, chosen by 4 others of the vicinage, and whose oaths gave a final decision to the contested claim. 1 Palgrave's Rise and Progress of the English Commonwealth, 261. From the moment when the crown became accustomed to the inquest, a restraint was imposed upon every branch of the prerogative. The king could never be informed of his rights, but through the medium of the people. Every extent by which he claimed the profits and advantages resulting from the casualties of tenure, every process by which he repressed the usurpations of the baronage, depended upon the good men and true, who were impaneled to pass between the subject and the sovereign; and the thunder of the exchequer, at Westminster, might be silenced by the honesty, the firmness, or the obstinacy of one sturdy knight or yeoman in the distant shire. Taxation was controlled in the same manner by the voice of those who were most liable to oppression. A jury was impaneled to adjudge the proportion due to the sovereign, and this course was not essentially varied, even after the right of granting aids to the crown was fully acknowledged to be vested in the parliament of the realm. The people taxed themselves, and the collection of the grants was checked and controlled, and perhaps in many instances evaded, by these virtual representatives of the community. The principle of the jury was, therefore, not confined to mere application as a mode of trying contested facts, whether in civil or criminal cases, and both in its form and in its consequences it had a very material influence upon the general constitution of the realm. The mainspring of the machinery of remedial justice existed in the franchise of the lower and lowest orders of the political hierarchy. Without the suffrage of the yeoman, the burgess, and the churl, the sovereign could not exercise the most important and most essential function of royalty. From them he received the power of life and death. He could not wield the sword of justice until the humblest of his subjects placed the weapon in his hand. 1 Palgrave's Rise and Progress of the English Constitution, 274-7. Coke says, "The court of the county is no court of record, and the suitors are the judges thereof." 4th Institutes, 266. Note: The ancient jury courts kept no records, because those who composed the courts could neither make nor read records. Their decisions were preserved by the memories of the jurors and other persons present. Also, the court of the hundred is no court of record, and the suitors be thereof judges. 4th Institutes, 267. Also, the court baron is a court incident to every manor, and is not of record, and the suitors be thereof judges. 4th Institutes, 268. Also, the court of ancient domain is in the nature of a court baron, wherein the suitors are judges, and is no court of record. 4th Institutes 269. Miller says, "Some authors have thought that the jurymen were originally compurgators, called by a defendant to swear that they believed him innocent of the facts with which he was charged. But the compurgators were merely witnesses. Jurymen were, in reality, judges. The former were called to confirm the oath of the party by swearing according to their belief that he had told the truth, in his oath of purgation. The latter were appointed to try, by witnesses, and by all other means of proof, whether he was innocent or guilty. Juries were accustomed to ascertain the truth of facts by the defendant's oath of purgation, together with that of his compurgators. Both of them, jurymen and compurgators, were obliged to swear that they would tell the truth. According to the simple idea of our forefathers, guilt or innocence was regarded as a mere matter of fact, and it was thought that no man who knew the real circumstances of a case could be at a loss to determine whether the culprit ought to be condemned or acquitted." First Miller's Historical View of English Government, chapter 12, page 332-4. Also, the same form of procedure which took place in the administration of justice among the vassals of a barony was gradually extended to the courts held in the trading towns. Same, page 335. Also, the same regulations concerning the distribution of justice by the intervention of juries were introduced into the baron courts of the king, as into those of the nobility, or such of his subjects as retained their allodial property. Same, page 337. Also, this tribunal, the aula regis, or king's court, afterwards divided into the courts of king's bench, common pleas, and exchequer, was properly and ordinarily baron court of the king, and, being in the same circumstances with the baron courts of the nobility, it was under the same necessity of trying causes by the intervention of a jury. Same, volume 2, page 292. Speaking of the times of Edward I, 1272 1307, Miller says, "What is called the petty jury was therefore introduced into these tribunals, the king's bench, the common pleas, and the exchequer, as well as into their auxiliary courts employed to distribute justice in the circuits, and was thus rendered essentially necessary in determining causes of every sort, whether civil, criminal, or fiscal." Same, volume 2, page 293-4. Also, that this form of trial by jury obtained universally in all the feudal governments, as well as in that of England, there can be no reason to doubt. In France, in Germany, and in other European countries, where we have any accounts of the constitution and procedure of the feudal courts, it appears that lawsuits of every sort concerning the freemen or vassals of a barony were determined by the pares curia, peers of the court, and that the judge took little more upon him than to regulate the method of proceeding, or to declare the verdict of the jury. Same, volume 1, chapter 12, page 329. Also, among the Gothic nations of modern Europe, the custom of deciding lawsuits by a jury seems to have prevailed universally, first in the allodial courts of a county, or of the hundred, and afterwards in the baron courts of every feudal superior. Same, volume 2, page 296. Palgrave says that in Germany, the Urafe, sheriff, placed himself in the seat of judgment, and gave the charge to the assembled free Eshva, warning them to pronounce judgment according to right and justice. 2 Palgrave 147. Also, that in Germany, the Eshva were composed of the villanage, somewhat obscured in their functions by the learning of the grave civilian who was associated to them, and somewhat limited by the encroachments of modern feudality. But they were still substantially the judges of the court. Same, 148. Palgrave also says, Scotland in like manner had the laws of borough law, or burr law, which were made and determined by the neighbors, elected by common consent, in the borough law or burgh courts, wherein knowledge was taken of complaints between neighbor and neighbor, which men, so chosen, were judges and arbitrators, and called burgh men. 1 Palgrave's Rise, etc., page 80. But, in order to understand the common law trial by jury, as it existed prior to Magna Carta, and as it was guaranteed by that instrument, it is perhaps indispensable to understand more fully the nature of the courts at which juries sat, and the extent of the powers exercised by juries in those courts. I therefore give in a note extended extracts on these points, from Stuart on the Constitution of England, and from Blackstone's Commentaries. Stuart says: "The courts or civil arrangements, which were modeled in Germany, preserved the independence of the people; and having followed the Saxons into England, and continuing their importance, they supported the envied liberty we boast of. As a chieftain led out his retainers to the field, and governed them during war, so in peace he summoned them together, and exerted a civil jurisdiction. He was at once their captain and their judge. They constituted his court, and having inquired with him into the guilt of those of their order whom justice had accused, they assisted him to enforce his decrees." This court, the court baron, was imported into England; but the innovation which conquest introduced into the fashion of the times altered somewhat its appearance. The head or lord of the manor called forth his attendants to his hall. He inquired into the breaches of custom and of justice, which were committed within the precincts of his territory, and with his followers, who sat with him as judges, he determined all matters of debt, and of trespass to a certain amount. He possessed a similar jurisdiction with the chieftain in Germany, and his tenants enjoyed an equal authority with the German retainers. But a mode of administration which entrusted so much power to the great could not long be exercised without blame or injustice. The German, guided by the candor of his mind, and entering into all his engagements with the greatest ardor, perceived not, at first, that the chieftain to whom he submitted his disputes might be swayed, in the judgments he pronounced, by partiality, prejudice, or interest, and that the influence he maintained with his followers was too strong to be restrained by justice. Experience instructed him of his error. He acknowledged the necessity of appealing from his lord, and the Court of the Hundred was erected. This establishment was formed both in Germany and England by the inhabitants of a certain division, who extended their jurisdiction over the territory they occupied. Note within note. It was the freemen in Germany, and the possessors of land in England, who were suitors, jurors, in the Hundred Court. These ranks of men were the same. The alteration which had happened in relation to property had invested the German freemen with land or territory. End of note within note. They bound themselves under a penalty to assemble at stated times, and having elected the wisest to preside over them, they judged, not only all civil and criminal matters, but of those also which regarded religion and the priesthood. The judicial power thus invested in the people was extensive. They were able to preserve their rights, and attended this court in arms. As the communication, however, and intercourse of the individuals of a German community began to be wider and more general, as their dealings enlarged, and as disputes arose among the members of different hundreds, the insufficiency of these courts for the preservation of order was gradually perceived. The shire mote, therefore, or county court, was instituted, and it formed the chief source of justice both in Germany and England. The powers, accordingly, which had been enjoyed by the Court of the Hundred were considerably impaired. It decided no longer concerning capital offenses. it decided not concerning matters of liberty, and the property of estates, or of slaves. Its judgments in every case became subject to review, and it lost entirely the decision of causes when it delayed too long to consider them. Every subject of claim or contention was brought in the first instance or by appeal to the county court, and the earl, or earldoman, who presided there, was active to put the laws in execution. He repressed the disorders which fell out within the circuit of his authority, and the least remission in his duty, or the least fraud he committed, was complained of and punished. He was elected from among the great, and was above the temptation of a bribe. But, to encourage his activity, he was presented with a share of the territory he governed, or was entitled to a proportion of the fines and profits of justice. Every man in his district was bound to inform him concerning criminals, and to assist him to bring them to trial; and, as in rude and violent times the poor and helpless were ready to be oppressed by the strong, he was instructed particularly to defend them. His court was ambulatory, and assembled only twice a year, unless the distribution of justice required that its meetings should be oftener. Every freeholder in the county was obliged to attend it, and should he refuse this service, his possessions were seized, and he was forced to find surety for his appearance. The neighboring earls held not their courts on the same day, and, what seems very singular, no judge was allowed, after meals, to exercise his office. The Druids also, or priests, in Germany, as we had formerly occasion to remark, and the clergy in England, exercised a jurisdiction in the hundred and county courts. They instructed the people in religious duties, and in matters regarding the priesthood; and the princes, earls, or earldomen, relating to them the laws and customs of the community. These judges were mutually a check to each other, but it was expected that they should agree in their judgments, and should willingly unite their efforts for the public interest. Note within note. It would be wholly erroneous, I think, to infer from this statement of Stuart that either the priests, princes, earls, or earldomen exercised any authority over the jury in the trial of causes, in the way of dictating the law to them. Henry's account of this matter doubtless gives a much more accurate presentation of the truth. He says that anciently the meeting, the county court, was opened with a discourse by the bishop, explaining out of the Scriptures and ecclesiastical canons their several duties as good Christians and members of the church. After this, the alderman, or one of his assessors, made a discourse on the laws of the land, and the duties of good subjects and good citizens. When these preliminaries were over, they proceeded to try and determine, first the causes of the church, next the pleas of the crown, and last of all the controversies of private parties. 3 Henry's History of Great Britain, 348. This view is corroborated by Tyrrell's Introduction to the History of England, p. 83-84, and by Spence's Origin of the Laws and Political Institutions of Modern Europe, p. 447, and the note on the same page. Also by a law of Canute to this effect: in every county let there be twice a year an assembly, whereat the bishop and the earl shall be present, the one to instruct the people in divine, the other in human, laws. Wilkins, p. 136. End of note within note. But the prince or earl performed not, at all times, in person, the obligations of his office. The enjoyment of ease and of pleasure, to which in Germany he had delivered himself over, when disengaged from war, and the mean idea he conceived of the drudgery of civil affairs, made him often delegate to an inferior person the distribution of justice in his district. The same sentiments were experienced by the Saxon nobility, and the service which they owed by their tenures, and the high employments they sustained, called them often from the management of their counties. The progress, too, of commerce, giving an intricacy to cases, and swelling the civil code, added to the difficulty of their office, and made them averse to its duties. Sheriffs, therefore, or deputies, were frequently appointed to transact their business; and though these were at first under some subordination to the earls, they grew at length to be entirely independent of them. The connection of jurisdiction and territory ceasing to prevail, and the civil being separated from the ecclesiastical power, they became the sole and proper officers of the direction of justice in the counties. The hundred, however, and county courts, were not equal of themselves for the purposes of jurisdiction and order. It was necessary that a court should be erected, of supreme authority, where the disputes of the great should be decided, where the disagreeing sentiments of judges should be reconciled, and where protection should be given to the people against their fraud and injustice. The princes accordingly, or chief nobility, in the German communities, assembled together to judge of such matters. The Saxon nobles continued this prerogative; and the king, or in his absence, the chief justiciary, watched over their deliberations. But it was not on every trivial occasion that this court interested itself. In smaller concerns, justice was refused during 3 sessions of the hundred, and claimed without effect at 4 courts of the county, before there could lie an appeal to it. So gradually were these arrangements established, and so naturally did the varying circumstances in the situation of the Germans and Anglo Saxons direct those successive improvements which the preservation of order, and the advantage of society, called them to adopt. The admission of the people into the courts of justice preserved, among the former, that equality of ranks for which they were remarkable, and it helped to overturn, among the latter, those envious distinctions which the feudal system tended to introduce, and prevented that venality in judges, and those arbitrary proceedings which the growing attachment to interest and the influence of the crown might otherwise have occasioned. Stewart on the Constitution of England, p. 222 to 245. In the Anglo-Saxon period, accordingly, 12 only were elected; and these, together with the judge, or presiding officer of the district, being sworn to regard justice, and the voice of reason, or conscience, all causes were submitted to them. Ditto, p. 260. Before the orders of men were very nicely distinguished, the jurors were elected from the same rank. When, however, a regular subordination of orders was established, and when a knowledge of property had inspired the necessitous with envy, and the rich with contempt, every man was tried by his equals. The same spirit of liberty which gave rise to this regulation attended its progress. Nor could monarchs assume a more arbitrary method of proceeding. "I will not," said the Earl of Cornwall to his sovereign, "render up my castles, nor depart the kingdom, but by the judgment of my peers." Of this institution, so wisely calculated for the preservation of liberty, all our historians have pronounced the eulogium. Ditto, p. 262 3. Blackstone says, "The policy of our ancient constitution, as regulated and established by the great Alfred, was to bring justice home to every man's door, by constituting as many courts of judicature as there are manors and towns of the kingdom, wherein injuries were redressed in an easy and expeditious manner, by the suffrage of neighbors and friends. These little courts, however, communicated with others of a larger jurisdiction, and those with others of a still greater power, ascending gradually from the lowest to the supreme courts, which were respectively constituted to correct the errors of the inferior ones, and to determine such causes as, by reason of their weight and difficulty, demanded a more solemn discussion. The course of justice flowing in large streams from the king as the fountain to his superior courts of record, and being then subdivided into smaller channels, till the whole and every part of the kingdom were plentifully watered and refreshed. An institution that seems highly agreeable to the dictates of natural reason, as well as of more enlightened policy. These inferior courts, at least the name and form of them, still continue in our legal constitution; but as the superior courts of record have, in practice, obtained a concurrent original jurisdiction, and as there is, besides, a power of removing plaints or actions thither from all the inferior jurisdictions, upon these accounts, among others, it has happened that these petty tribunals have fallen into decay, and almost into oblivion; whether for the better or the worse may be a matter of some speculation, when we consider, on the one hand, the increase of expense and delay, and, on the other, the more able and impartial decisions that follow from this change of jurisdiction. The order I shall observe in discoursing on these several courts, constituted for the redress of civil injuries, for with those of a jurisdiction merely criminal I shall not at present concern myself. Note within note. There was no distinction between the civil and criminal courts as to the rights or powers of juries. End note within note. Will be by beginning with the lowest, and those whose jurisdiction, though public and generally dispersed through the kingdom, is yet, with regard to each particular court, confined to very narrow limits, and so ascending gradually to those of the most extensive and transcendent power. 3 Blackstone, 30-32. The court baron is a court incident to every manor in the kingdom, to be holden by the steward within the said manor. This court baron is of two natures. The one is a customary court, of which we formerly spoke, appertaining entirely to the copyholders, in which their estates are transferred by surrender and admittance, and other matters transacted relative to their tenures only. The other, of which we now speak, is a court of common law, and it is a court of the barons, by which name the freeholders were sometimes anciently called; for that it is held by the freeholders who owe suit and service to the manor, the steward being rather the registrar than the judge. These courts, though in their nature distinct, are frequently confounded together. The court we are now considering, viz., the freeholders' court, was composed of the lords tenants, who were the pares (equals) of each other, and were bound by their feudal tenure to assist their lord in the dispensation of domestic justice. This was formerly held every 3 weeks, and its most important business is to determine, by writ of right, all controversies relating to the right of lands within the manor. It may also hold pleas of any personal actions, of debt, trespass in the case, or the like, where the debt or damages do not amount to 40 shillings, which is the same sum, or 3 marks, that bounded the jurisdiction of the ancient Gothic courts, in their lowest instance, or fyrding courts, so called because 4 were instituted within every superior district or hundred. 3 Blackstone, 33-34. A hundred court is only a larger court baron, being held for all the inhabitants of a particular hundred instead of a manor. The free suitors are here also the judges, and the steward the registrar, as in the case of a court baron. It is likewise no court of record, resembling the former at all points, except that in a point of territory it is of greater jurisdiction. This is said by Sir Edward Coke to have been derived out of the county court for the ease of the people, that they might have justice done to them at their own doors, without any charge or loss of time; but its institution was probably coeval with that of hundreds themselves, which were formerly observed to have been introduced, though not invented, by Alfred, being derived from the polity of the ancient Germans. The Centeni, we may remember, were the principal inhabitants of a district composed of different villages, originally in number 100, but afterward only called by that name, and who probably gave the same denomination to the district out of which they were chosen. Caesar speaks positively of the judicial power exercised in their 100 courts, and courts baron. Princeps regiorum atque figuram, which we may fairly construe the lords of hundreds and manors. Inter suos jus dicunt, controversias quae minunt. The chiefs of the country and the villages declare the law among them, and abate controversies. And Tacitus, who had examined their constitution still more attentively, informs us not only of the authority of the lords, but that of the centeni, the hundreders, or jury, who were taken out of the common freeholders, and had themselves a share in the determination. Eliguntur in conciliis et principes, qui jura per pagos vicosque redunt, centene singulis, ex plebe comitas concilium simul et auctoritas adsunt. The princes are chosen in the assemblies, who administer the laws throughout the towns and villages, and with each one are associated 100 companions, taken from the people, for the purposes both of counsel and authority. This 100 court was denominated haereda in the Gothic constitution; but this court, as causes are equally liable to removal from hence as from the common court baron, and by the same writs, and may also be reviewed by writ of false judgment, is therefore fallen into equal disuse with regard to the trial of actions. 3 Blackstone, 34-35. The county court is a court incident to the jurisdiction of the sheriff. It is not a court of record, but may hold pleas of debt or damages under the value of 40 shillings, over some of which causes these inferior courts have, by the express words of the statute of Gloucester, 6 Edward I, chapter 8, a jurisdiction totally exclusive of the king's superior courts. The county court may also hold plea of many real actions, and of all personal actions to any amount by virtue of a special writ, called a justitias, which is a writ empowering the sheriff, for the sake of dispatch, to do the same justice in his county court as might otherwise be had at Westminster. The freeholder of the county court are the real judges in this court, and the sheriff is a ministerial officer. In modern times, as proceedings are removable from hence into the king's superior courts, by writ of pone or recordari, in the same manner as from the 100 courts and courts baron, and as the same writ of false judgment may be had in nature of a writ of error, this has occasioned the same disuse of bringing actions therein. 3 Blackstone, 36-37. Upon the whole, we cannot but admire the wise economy and admirable provision of our ancestors in settling the distribution of justice as a method so well calculated for cheapness, expedition, and ease. By the constitution which they established, all trivial debts and injuries of small consequence were to be recovered or redressed in every man's own county, hundred, or perhaps parish. 3 Blackstone, 59. End of chapter 3, part 3.